blindly support the judicial officers. Where the judicial officer goes wrong, if he is found to be corrupt, or if he ignores the binding precedents or law, whatever it is, then in such cases action should be taken. Ignoring that again is another problem. The judge thinks he is a boss, he is totally supreme, and whatever order I want to pass, I will pass. Come on, file an appeal. You have no business to question me. This kind of attitude is another extreme. This has to be checked. File counters and then hold inquiries. It's like this. Let me give one illustration. A pilot of an aeroplane, once he enters the cockpit, you might have noticed there are so many controls and switches. Delhi, the demeanor of the judge towards the bar. Judges should be taught to display the right demeanor while dealing with the bar, which, as explained earlier, consists of unofficial judges. They should not assume that they are the headmasters disciplining their pupils. They should not frown at advocates or shout at them. In a school, the headmaster educates the pupils, whereas in the court of law, it is the advocates who enlighten the judge on both the legal and factual aspects of a case. Rule 1, subclause C. The fact that the pleader of a party is engaged in another court shall not be a ground for adjournment. Clause D. Where the illness of a pleader or his inability to conduct the case for any reason other than his being engaged in another court is put forward as a ground for adjournment, the court shall not grant the adjournment unless it is satisfied that the party applying for adjournment could not have engaged another pleader in time. Subclause E. Where a witness is present in court but a party or his pleader is not present, or the party or his pleader, though present in court, is not ready to examine or cross-examine the witness, the court may, if it thinks fit, record the statement of the witness and pass such orders as it thinks fit, dispensing with the examination in chief or cross-examination of the witness, as the case may be, by the party or his pleader not present or not ready as aforesaid. For instance, an advocate practicing in Delhi might accept cases from the junior civil judge court to the Supreme Court. When the matter is called in the junior civil judge court, the junior advocate represents that his senior is conducting a case in the Supreme Court. The judge waits till 5 p.m. and adjourns it to the next day. On that day, the said junior represents that his senior is engaged in Delhi High Court. The judge adjourns the same on the same day to the next day. Again, the junior represents that his senior is engaged in the Sessions Court and later in the Assistant Sessions Court and later in the Metropolitan Magistrates Court, and so on. What will happen to the matter that should have been taken up promptly in the junior civil judges court? Why should the opposite party or his advocate suffer because the defaulting party had engaged a very eminent and overworked advocate? Even film stars say no to producers when they are unable to give call sheets. Keeping this in mind, the aforesaid provision of law was inserted in the Civil Procedure Code long ago. For fear of antagonizing the bar, I repeat, for fear of antagonizing the bar, the judicial officers are unable to enforce this provision, resulting in delay in the judicial process. Now, in such cases, the Honorable High Court has the responsibility of coming to the rescue of the poor judicial officer who is being troubled by the bar, because the judge is enforcing the law strictly. If the Honorable High Court also advises, come on, be diplomatic with the bar. Why are you so strict about procedure? Then what happens? The judge is not supposed to be diplomatic. He is supposed to be decisive. I repeat, a judge is supposed to be decisive and not diplomatic. He is not just a diplomat. Diplomats deal with foreigners. We have no power over foreigners, therefore they speak in a very, very pleasing manner, very indirect manner, whereas judge has all the powers to control the proceedings. Problem is, if he doesn't enjoy the support of the High Court, trouble will come. So judicial officers are rarely courageous enough to enforce all these provisions. So it is the responsibility of the Honorable High Court to back the judicial officers when they are strictly following the law. I'm not saying that they should blindly support the judicial officers. Where the judicial officer goes wrong, if he is found to be corrupt, or if he ignores the binding precedents or law, whatever it is, then in such cases action should be taken. Ignoring that again is another problem. The judge thinks he is a boss, he is totally supreme, and whatever order I want to pass, I will pass. Come on, file an appeal. You have no business to question me. This kind of attitude is another extreme. This has to be checked. But having said this, when the judge is following the law, just because a section of the bar doesn't like it and raises a hue and cry, even passes resolutions, the judge should be unmoved, and the High Court also should back him strictly. Now, having said this, I am suggesting a workable compromise to accommodate the bar also, because after all, the bar is also a part of the judiciary. It's an indispensable part, and I even go to the extent of saying that advocates are unofficial judges. I'll speak about it in greater detail in another topic, but for the time being, some accommodation is to be shown to the advocates. How to do that? This is what I'm now going to show. When a representation is made that an advocate is held up in another court, the judge may pass over the matter for 1 hour initially. If the advocate doesn't turn up, it may be taken up in the post-lunch session. Again, if the advocate doesn't conduct the case citing the same reason that he is held up in some other court, it may be adjourned to the next day on a nominal cost of rupees 50 or rupees 100. At least on the next day, by applying the day-to-day posting procedure which is mandated by law, if the senior advocate gives the same reason for not conducting the case, the judge may refuse to pass over the matter and order the next step, like closing the evidence of that particular witness or that particular side, or dismiss the matter for default, or set the defendant ex parte and decree the suit ex parte summarily. Where substantial portion of evidence is already recorded, this is important. Most people don't know about this legal position. Where substantial portion of evidence is already let in by both the parties, the judge may pronounce judgment on merits also, as laid down by the Honorable Supreme Court in B. Janaki Ramaya Chetty versus A.K. Parthasarathi, reported in AIR 2003, Supreme Court 3527, in which case only an appeal lies. When an application is filed promptly, say the very next day or within 3 days, to restore the suit or whatever may be the proceeding, or recall of the witness, the judge may summarily allow such application by imposing costs of rupees 500 for the first time without wasting time on counters and enquiries. This is very important. Nowadays, most of the judicial officers, they never practiced as lawyers. They are straight away being recruited after passing a test, and they are nonplussed what to do. So whenever any petition is filed, they promptly give a date for counter, pray time, again counter, again pray time for counter. It goes on like this. That's a criminal waste of time. Earlier also, experienced judges used to do this, and even the superior courts used to uphold their orders. So they should not waste the time of the court in every small interlocutory application by giving opportunity to file counters and then hold enquiries. It's like this. Let me give one illustration. A pilot of an aeroplane, once he enters the cockpit, you might have noticed there are so many controls and switches. Many switches are on the roof of the plane because the space in front of the pilot and below the pilot, they are insufficient, so they are accommodated on the roof. Then so many dials in front, and then some big controls like landing control of the landing gear, then the rudder control, what you call steering for cars. So these things are there. The pilot will not give same importance to each and every control. Certain things require greater attention, like correctly operating the landing gear or correctly maintaining the position of the rudder or whatever it is. I'm not a pilot. But there are small switches like control of lights or microphone or whatever it is. He simply touches them. That's all. That is enough to operate it properly. Similarly here, when the judge is conducting the proceeding, small interlocutory applications like delay condonation petitions in filing documents, then petitions to set aside ex parte orders, ex parte decrees. These things are recall of witnesses. These things, the judge can boldly say, what, Mr. Opposite Advocate, why do you waste the time of the court in filing counter and enquiry and all that? Come on, I'm going to summarily allow this on heavy costs, don't worry, so that he won't repeat the same mistake again. So saying, he can get the most advocates' consent. Even if the advocate doesn't consent, doesn't matter. The judge can go ahead, and if any appeal is filed, definitely the appellate courts will support the judge, because these are all small switches, just like as I said, small switches in a cockpit. So this will go a long way in curtailing delays. So without wasting time on counters and inquiries, and if the same thing is repeated, the summary restoration may be done by imposing costs of rupees 1000 and finally rupees 2000. See, begin with 500, then go to 1000, then rupees 2000. Costs are supreme panacea for all procedural ills. This is what the Honorable Madras High Court has said. I'm not able to recollect that ruling immediately. So costs are the supreme panacea for all these procedural ills. If the same thing is repeated even after restoration of the suit for the third time on cost of rupees 2000, the judge may give just one adjournment for filing counter, if any, to the next day by opposite side, and decline to restore the suit, citing the entire history of the conduct of the party. Of course, this may not apply if really strong ground is shown, like serious ailment of the party or advocate or accident resulting in injuries, to seek restoration for the fourth time also. Now, what are the advantages of this procedure? Advantages to litigants, junior advocates, and the judges. This procedure will give clarity and confidence to the judicial officers about the course they may adopt to deal with such tricky issues with the bar. This will also compel senior advocates to recruit competent junior advocates by paying them appropriate fee, so that the junior advocates who get opportunities to learn the work can progress in the profession. At present, they are merely confining themselves to represent during the call work and spend the rest of the day idling. When there is progress in the suits, the seniors also can afford to pay a decent fee to their juniors, whether from their own pocket or from the clients. The law also allows 1/3 fee to juniors additionally. If a senior of 15 years standing takes a junior to assist him, this facility is given. At present, seniors might not afford to pay decent fee to juniors, as courts are not showing progress in matters for fear of antagonizing the bar in restricting adjournments, or due to their lack of experience to pronounce judgments. Some new recruits in judicial officers are not pronouncing judgments even after several months of completion of arguments. The law mandates pronouncement of judgment at once. I have spoken about this in detail earlier. After hearing arguments, or at least within 1 month, and in rare cases 3 months. Then another very interesting topic: how to deal with impolite and arrogant advocates. Though advocates are officers of the court and they are unofficial judges, according to me, and judges can be punished for contempt for insulting advocates. This is important. See, a judge can be punished if he treats an advocate with insult. This was laid down in a decision of the Honorable Lahore High Court way back in the year 1949, and this is reported in AIR 1949 Lahore 270. Though this power is there, their conduct has to be properly regulated. That means to say, the advocate's conduct has to be properly regulated by the judge, just as the Speaker of the Lok Sabha regulates the procedure therein by exercising the necessary control over fellow parliament members, including the Prime Minister, the Finance Minister, the Defense Minister, etc., who are all very powerful personalities outside the Parliament, but who should be controlled by the Speaker of the Lok Sabha. The Chairman of the Rajya Sabha also does the same thing while dealing with the Rajya Sabha members. The members can be controlled by cutting the power supply to the microphone, by calling the marshals to forcibly expel the members who resort to violence, and ultimately suspend the members for the rest of the day or for the rest of the session. Similarly, junior judicial officers and even mandal revenue officers, while conducting judicial or quasi-judicial proceedings, can control them, I mean to say the advocates, with the help of Section 345 Criminal Procedure Code. Section 345 Criminal Procedure Code, I repeat, which empowers these judicial officers to summarily try the culprit who disturbs the proceedings or attacks the presiding officer orally or physically by convicting him and imposing a fine of rupees 200. If this is not paid, even imprisonment can be imposed, not exceeding 1 month period. Advocates who behave rudely with judges also should be dealt with in the same fashion. Since the fine is only rupees 200, if an innocent advocate is wrongly convicted, he can easily pay the amount, or fellow advocates may lend that amount to him and challenge the order in appeal. Young and inexperienced judicial officers are actually scared of advocates behaving rudely and are not able to assert themselves to ensure uninterrupted conduct of the judicial proceeding. The next topic would be the demeanor of the judge towards the bar. Judges should be taught to display the right demeanor while dealing with the bar, which, as explained earlier, consists of unofficial judges. They should not assume that they are the headmasters disciplining their pupils. They should not frown at advocates or shout at them. In a school, the headmaster educates the pupils, whereas in the court of law, it is the advocates who enlighten the judge on both the legal and factual aspects of a case. Having said this, judges also should learn to be firm when enforcing the mandatory provisions of law. To illustrate, suppose an advocate unreasonably seeks adjournment, the judge should firmly curtail him by saying, with a neutral demeanor, open quote, the request for time is refused for reasons so and so, close quote. The judge should not shout at the advocate, as ill-treating an advocate is also contempt, as stated earlier. If a judge habitually displays this attitude, the aggrieved advocate should not hesitate to file a petition against the judge for contempt as per the ratio in AIR 1949 Lahore, which was already cited earlier. Similarly, during the course of trial, if any objection is taken for marking any document, the judge must crisply say, open quote, objection sustained, close quote, or objection overruled. Advocates also should, of course, be polite and respectful towards the judges. If the advocate whose objection was overruled shouts at the judge or grumbles expressing his displeasure or accuses the judge in the court hall that he is not impartial, the latter should demand an apology, failing which action should be initiated under section 345 CRPC as explained in detail earlier. This role is similar to that of a speaker in the legislature. How to minimize call work and expedite the judicial process. Trial of cases. Posting of cases both on the original side and the execution side as per the civil rules of practice is mandatory. Since mandatory provisions are like railway tracks, ignoring them amounts to derailment of the judicial train, which is harmful to the society. The following is the prescribed mandatory procedure which has been flouted all these years due to lack of commitment of both the bench and the bar to render quick justice. I am quoting Andhra Pradesh High Court rules. There may be different numbers in other High Court rules, but in all probability the substance would be the same. So far as Andhra Pradesh High Court rules are concerned, Rule 66, it deals with preparation and publication of special list. What this rule says is, the judges should obtain the necessary information from the advocates and then prepare a special list for each month. In the special list, they must identify by giving the names of the parties and the number assigned to each case and the advocate appearing, and it should be published at least 1 month in advance so that the advocates will come to know in advance which matters are going to be taken up in the next month. Now, if this procedure is followed, the following benefits will accrue. A. Parties to the litigation can allot their time exclusively to pursue their suits for the 15 days or 1 month when their cases are listed by following the above procedure. B. Advocates can come to know in advance which matters would be taken up for trial and can summon their clients and advise them to obtain all the documents and certified copies from public offices so that the trial can go on without interruption on a day-to-day basis. Advocates also can plan in advance to allot simple cases to their juniors and keep difficult cases to be handled by the seniors personally. This will also give an opportunity to junior advocates to learn from practical experience the method of conducting trials and advancing arguments under the guidance of seniors. At present, the junior advocates are forced to confine themselves to represent in the call work and spend the rest of the day idling while pretending to watch the seniors conducting the cases. Advocates also can remember what happened on the previous posting, as matters are posted on a day-to-day basis most of the time. See, when interlocutory applications are filed, day-to-day posting will prevent frivolous petitions intended just to delay a proceeding. Even if petitions to impede parties are filed under Order 1, Rule 10 CPC, the court need not adjourn the trial indefinitely till the notices are served on the proposed parties and final orders are passed in these said applications. Witnesses can be recalled after the parties are impleaded if they so desire, and if the court is satisfied that this requirement is genuine. Sometimes the questions that are to be put by the newly added parties, if they are already put by the advocate for the previous party, for the party who is already on record, there is no need to recall that witness. It all depends upon the facts of each case, but there is no point in adjourning the trials just because petitions to implead parties are filed. Then, if any important witness is not available for an extended period of time, the court can temporarily close the evidence of a particular side with liberty to examine the key witness who could not be examined earlier due to his non-availability. The court can examine any witness at any time as laid down in Order 18, Rule 16 and 17, and rulings under those provisions. Suppose the advocate represents, no sir, no Mr. Judge, the proposed witness has gone to, say, Delhi, he will not come back for 15 days. It doesn't mean that the trial should be adjourned for 15 days. The next witness can be examined, and if the proposed witness is the last witness, let the judge close the evidence tentatively with liberty to the party to examine that witness after he returns and complete the evidence of the other side. So that's why the law also says court can examine any witness at any stage. Then, under Order 41, Rule 5, an appeal shall not operate as a stay unless the appellate court so orders, which becomes operative from the date of communication of stay or when an affidavit is filed by the appellant that stay is granted. Courts may not keep on adjourning matters on the ground that an appeal is filed. At its discretion, court may grant 2 adjournments not exceeding 1 month period altogether to enable the appellant to get stay. This is only a suggestion. This will also cut down delays. Restitution can always be ordered if the appellant succeeds in the appeal under Section 144 CPC. In fact, when I was a junior, I remember very well, the executive court would never grant time to the judgment debtor to get stay from the appellate court. They used to say nothing doing. Once the EP is filed, I'm going to order the next step, whether it is ordering delivery or whatever it is. It is for you to get the stay by now. And after great amount of persuasion, the judge used to grant, say, 3 days or 4 days or maximum 1 week and maximum 1 month. But nowadays, on account of lack of training and lack of experience as advocates before their recruitment as judicial officers, the judges are confused what to do. This advocate says appeal is there in the High Court, that too, and stay petition also is there. So should I wait? If I don't wait, what happens? Will the High Court find fault with me? So these are all the fears. So the trial courts are endlessly adjourning matters. Especially execution proceedings. If the cause list system is introduced, some advocates might be apprehensive that it might cause anxiety to the advocates to conduct trials on a day-to-day basis. This apprehension need not be entertained because under the cause list system, advocates will come to know a month in advance the matters that will be taken up for trial in the coming month. This much time is enough to instruct the parties to be ready with the copies of the necessary documents and the list of proposed witnesses. In fact, under this system, the moment the written statement is filed, advocates will come to know the points that are in dispute and can suitably instruct the clients to be ready with the documentary and oral evidence well in advance, so that once the matter is listed for trial, day-to-day evidence recording will not pose any problem. Of course, some advocates want to deliberately delay the proceedings and they may not cooperate. We should realize that if we should prevent the litigants from approaching rowdies to settle their scores, if we should change our habits so that in the long run, the majority in this profession will become prosperous. There is no shortcut to prosperity. Why medical profession is prosperous? Because doctors give prompt treatment. So is engineering. Why lawyers are suffering? Except a few, like film stars. They may be earning a lot, but the majority are suffering. Everybody knows. Why? If we don't deliver the goods, this will worsen. The bench and the bar have no right to suspend any law or repeal it. No doubt, the judiciary can strike down a law if it is opposed to the Constitution of India. Without following such a procedure, the judiciary has no business to ignore the law by treating it as a mere black impression on white paper. It should enforce the law as it stands and not as per its convenience by treating it as a mere guideline which might be crossed at will. Why I am saying this is, though the law mandated day-to-day posting of matters and identifying matters and publishing lists, nobody has been following this. Interim orders like prohibitory injunction and attachment before judgment are like first aid by a hospital. Merely ordering urgent notice will result in serious loss to the parties. This topic is dealt with in another video presentation. Controlling cross-examination. This is another contentious issue. Sometimes the bench and the bar clash on the scope of cross-examination of witnesses. Advocates claim that their right to cross-examine should not be interfered with by the judge when the judge asserts that he does have a right to control the scope of cross-examination. In this respect, Section 138 of Evidence Act can be usefully referred to. The said section prescribes that cross-examination should be confined to relevant facts. It means the fact should be relevant to a fact in issue. In any case, if a citation is required, there is 1985-3 Andhra Pradesh Law Journal, page 72. T. Chenchayya versus State of Andhra Pradesh. Suppose in a money suit, the advocate for the defendant wants to put a question to the plaintiff: who is the President of the United States at present? Clearly, it is neither a fact in issue nor a relevant fact. The judge has the right to restrain the advocate from such cross-examination. In fact, the judge has a duty also. And such cross-examination goes on for hours, wasting precious time of the court, apart from the time of other advocates and parties who are waiting for their cases to be taken up. If the advocate tries to attack the judge orally, of course, the judge should be bold enough to assert his power. Section 345 CRPC is the best remedy for judicial officers. But unfortunately, neither the bar nor the bench has been made aware of this provision all these years. Judicial officers usually express helplessness, saying it is only the high courts that have power to punish for contempt, and what can we do? It is high time judicial officers are trained on these lines to properly control court proceedings. Videographing all court proceedings by default, except for certain delicate matters like sexual assault cases, would be very useful to decide whether the judge has committed any wrong or whether it is the advocate who is the wrongdoer. The next topic is imposition of costs. Section 35B CPC deals with the procedure for imposing costs for causing delay. The provision reads, open quote, if on any date the court may, for reasons to be recorded, make an order requiring such party to pay to the parties such costs as would in the opinion of the court may reasonably be sufficient to reimburse the other party in respect of the expenses incurred by him in attending the court on the date. Close quote. Such costs should be paid to the parties only to compensate for the expenses incurred by them in attending the court. Rule 109, Civil Rules of Practice. It deals with costs of adjournment, except where an adjournment is necessitated by the business of the court or by the act or default of any other party, and party desiring an adjournment may be ordered to pay the cost thereof, including the expenses of resummoning the witness, if any, and the fee of the advocate of the other party. Now, what is happening is, even though the court awards costs, the bar is appropriating it, and they are by resolution, they are contributing these costs to the bar associations to meet their expenses. This is highly illegal and unethical, because the law intends that the opposite party was disappointed due to the adjournment and he should be compensated, and it awards cost. What is the point in the bar attaching that and then appropriating it to itself? And judges rarely question the bar, because why should we antagonize the advocates? And then judges also come forward with all kinds of requests to the bar. You arrange this program, that program, and who will pay for it? The government doesn't pay. There are no funds for the judiciary to pay for these things. So why should the advocates pay? So these costs will help. This is the kind of understanding that goes on at the cost of the litigant. Other costs. The court may also impose costs for seeking adjournment to file pleadings, advance arguments, etc., where only the advocates are present and there is no need for the parties or witnesses to attend the court. In Satyapal Singh versus Union of India, the Honorable Supreme Court laid down that costs belong to the parties only, and only when both the parties to the litigation are equally guilty, the court may award costs to a third party like the State Legal Services Authority. Therefore, the advocates should be bold enough to represent. We oppose the judge awarding costs to the Legal Services Authority. It should go to the parties. Quantum of costs. Earlier, there were some limitations on the amount of costs that may be imposed by the courts, but now That limit appears to have been removed. When judges impose heavy costs, there is usually a dissent expressed by the advocates, though they are not able to pinpoint the provision of law which imposes such limits. Generally, advocates feel that if costs exceed rupees 300, the award is excessive just for granting adjournments. By way of a suggestion, I suggest that the judge may impose rupees 100 as costs initially and progressively increase it up to 300. If the parties do not get ready, even then the courts may resort to dismissal of the proceedings or proceed ex parte against the contesting parties who are negligent. If applications are filed to restore the matters which are dismissed for default or decided ex parte, the court may, without wasting time on counters and enquiries, summarily allow such applications for the first time on costs of rupees 500 or rupees 1000, then for the second time rupees 2000. And this aspect was already considered in the earlier part of this video, so it's not proper for me to repeat it. Now the difference is this: a cost for mere adjournment may begin with rupees 100 and may progressively be increased to rupees 300. But when a matter is dismissed for default, this is very important, and when a restoration petition is filed, nowadays judges are ordering, come on, file counter and pray time for counter, yes, time extended. It goes on, this process goes on for another 2 months. That is wrong. The best course is to allow such applications summarily by imposing heavy costs. As I said earlier, first time rupees 1000, second application for restoration, if it is dismissed again, 2000 rupees, and in some cases, third application also may be allowed by imposing 3000 rupees. Then appeals. Order 41, Rule 11, Civil Procedure Code mandates that appeals shall be disposed of within 60 days from the date of presentation of the appeal. Unfortunately, the judiciary has never taken this provision seriously, though it is mandatory, and this provision was introduced way back in the year 1977. Both the bench and the bar should equally share the blame for this flagrant violation of the law. The Constitution of India has granted a great degree of independence to the judiciary, hoping that it may not need any supervision or correction either by the executive or by the legislature. As Mr. Justice M.N. Venkatachalaya, former Chief Justice of India, had lamented, if the judiciary doesn't correct itself, a day might come when such corrective steps may be forced on the judiciary by external agencies. After all, while deciding appeals, only interpretation of the record is involved, and it can be done easily if the bench and the bar show the necessary determination and commitment to follow the law. What happens if the judge alone shows the determination but not the bar? Simple. The judge can post the matter for final hearing within 2 months or within, say, maximum 6 months from the date of filing of the appeal. And if the advocate for the appellant doesn't get ready, first time grant adjournment and on imposition of some 100 rupees, post it to the next day, then again next day 200 rupees, third time 300 rupees, fourth time dismiss it for default. That's all. So this is the way to control the bar. The judge should not feel helpless, as if he has no powers at all. How can I control the bar? It's not. It's only inefficiency and lack of proper training, I must say. Then, in Adoni, in Andhra Pradesh, where I am practicing, appeals are pending for nearly a decade. Even civil miscellaneous appeals, which are filed against some important interlocutory orders like granting temporary injunction or etc., are not even being heard even after 6 years. This has resulted in halting of the proceedings in the lower courts on their tracks, as documents are usually sent to the appellate courts and the trial courts rarely compel the advocates to be ready for trial in the absence of a stay by the appellate court. The same situation prevails even in the honorable high courts, which are constitutional courts and expected to set an example to the lower judiciary. An exasperated Supreme Court directed some time ago that if the appellate courts do not dispose of appeals or revisions within 6 months, the orders of stay of the proceedings in the trial court are deemed to have been automatically vacated. Even this has not changed the situation in the higher judiciary for reasons best known to them. It would be a good idea if the Chief Justices of the High Courts give a direction to all the judges of the High Courts to give first priority to appeals from the trial court's judgments. First appeals and second appeals are pending in the High Courts even for as long as 15 years, mind you, 15 years. Advocates who took the lead during the freedom struggle and antagonized the high and mighty in the British Empire have now become pussycats, afraid of reminding the judges to perform their lawfully enjoined duties. The Judicial Standards and Accountability Bill, which was passed by the Lok Sabha nearly 10 years ago, was kept pending before the Rajya Sabha, and ultimately the bill was allowed to lapse. Nobody is showing any interest in reviving the bill. It is only for the legal profession to take the lead once again, educate the public, and make them demand the politicians to pass such a law to oversee the conduct of the higher judiciary and give scope to whistleblower advocates practicing in the higher judiciary to bring complaints to the notice of the high-powered body to look into allegations against higher judiciary. Similar institution already exists in the United States. So far as I know, I have seen only Mr. Prashant Bhushan, who is a whistleblower, and he has been facing contempt petitions. And recently, the Supreme Court, the Honorable Supreme Court, imposed only ₹1 fine. Though he said, okay, no, my lord, you can send me to jail. You can impose whatever punishment you want. The judge, he realized that he must have committed a mistake, but his ego was coming in the way. So he imposed a fine of ₹1, and then the matter was closed there. And even that ₹1 was paid under protest. He has filed some appeal or whatever proceeding is there to the next bench or some sort of a review. I'm not so conversant with the procedure in the Supreme Court, as I'm a trial court lawyer. Very few lawyers are having that courage and commitment in the higher judiciary to expose the inadequacies of the honorable judges there. At least in that sense, people like me who are practicing in the subordinate judiciary, we are in a better position because we have the duty and the right to complain to the Honorable High Court, and when written complaints are sent, the Honorable High Court also is ordering inquiries. So that fear will be there in the judicial officers. But in the higher judiciary, there is no such forum. But now, subsequently, due to a judicial pronouncement, a certain internal mechanism was evolved. If the complaint is against a High Court judge, then again give it to the Chief Justice. And if the complaint is against the Chief Justice, give it to the Supreme Court or some such thing. Some a committee will be appointed. They can look into it. And the Chief Justice can stop allocating work to that judge because he cannot dismiss that judge. Even the Supreme Court cannot dismiss a High Court judge. So after the committee finds him guilty, then it may be referred to Parliament. Only Parliament can impeach him. So that is the difficult procedure. Of course, these safeguards are required to the higher judiciary because they always decide difficult constitutional questions, and they have to often antagonize the legislature and the executive. But that doesn't mean that they are gods from the heavens. So some mechanism is to be designed. Even in America, that is already there. A commission or committee for judicial accountability. That is the name. Yes, that is in America. Some such committee is to be instituted here. Why nobody is bothered? Probably our parliamentarians are not so much interested in setting the judiciary in order. So it is for the people to demand. People will not demand unless the advocates educate them. Advocates will not educate them unless their attention is brought to these things. That's what I'm now trying to do through this video. Thank you.